topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good afternoon, South Florida. Welcome to another Ask the Expert show, where we bring you the finest experts in the field of legal, health, financial, and home improvement. This is the first Thursday of the month, our 5 o'clock Eastern Standard Time show, and we are going to be talking about community association law. We've got one of the senior partners, board-certified attorney Robert Kay, with us. Good afternoon, attorney.
Good afternoon, Steve, and hello, everybody.
Boy, you have got a busy schedule for November with your class.
Before Thanksgiving.
That's right. That's right. You know, Robert, you are, with all of our 37, 38 shows, are the most popular show, our South Florida show. Though our Orlando show is really catching up.
Good.
Yes, and Tampa is right behind them, but we get more letters and emails. People have questions to ask, and people just love your show. They love how you communicate. They love basically your education, and we are so lucky to have you. So we're getting all these new people finding the show. Tell people about K. Bender Rembaum.
Okay, well, K. Bender Rembaum is a full-service law firm that focuses on community association representation, condominiums, homeowner association, cooperatives primarily, providing all of the day-to-day legal advice and then services for associations that they may need, from interpreting documents, providing opinions, doing demand letters for violations, negotiating contracts, pursuing unpaid assessments, covenant violations, construction defect litigation, anything and everything that an association is going to deal with on a day-to-day basis of a legal nature is the area where we focus our attention. The firm has 4 offices currently, Pompano Beach, our main office, Palm Beach Gardens, Orlando, is it Winter Park? And we just moved over there. And then in Tampa. We're all available by Zoom for sure. So wherever we are in the state, we have the ability to provide our services remotely as well as in person. What else can I tell you? We've got 10 Florida board certified attorneys specializing in the area, including one in construction defect.
We got a call before the show, somebody wanting to know, are you in Jacksonville at all? Do you cover Jacksonville? I know you don't have an office there.
We could remotely do it. Orlando is the closest we have to Jacksonville.
Okay.
But that's where we're at currently.
Well, we have got a ton of questions to ask you today. And, thank you so much for people who take the time to write these questions. Robert, has it calmed down since all the new laws are going into effect?
No, I wouldn't say that. I think that it takes a while for that to all settle in. People are still dealing with, in the condominium arena, the changes that were made last year relative to the inspection requirements and the new reserve requirements that are going into effect after the first of the year. So, that's been a long time in evolving. And then this year there was a large number of changes in both condominiums and HOAs. So that takes a while to settle in. One of the big changes is the new requirements of education to be certified to continue to serve on the board. And those education requirements required all new courses, and 4-hour long courses are quite different than the 1-hour ones that we had been doing previously. So that's something that takes some time to create, as well as figuring out, is one person going to sit for 4 hours, or are we going to do multiple attorneys making presentations? And we're working through that.
But it's a positive, don't you think?
Oh, yeah, all positive.
Great. Well, let's go to our listeners. Jack in West Palm Beach, he said, I bought into a community and now I'm being told there's restrictions I don't like. I think he wrote us several months ago. How was I supposed to know?
Well, when you buy property in Florida, it's should be fairly common knowledge, although people coming from out of state may not have this common knowledge, that most of the communities have deed restrictions, such as declarations of covenants and homeowner association declaration, and certainly in condominiums, they're all restricted. It's important to involve legal assistance when buying real property, either through an attorney or through a title insurance company that would provide you the information of knowing what restrictions are in place. They're all a matter of public record, being recorded in the county that the property is located in. And it's something that it's the buyer's obligation to know about. Now, there's supposed to be disclosures by real estate salespeople at the time of entering into the purchase agreement. I think where people often get caught in this situation is when they're doing a private situation between individuals and they don't have the assistance of the experts. That's when people get caught.
Let's go to Bo in Delray Beach. Do condos have to have a quarterly meeting?
Well, one of the changes that was adopted in Chapter 718 this year is a requirement that a board meet at least 4 times a year, quarterly, whether they have anything to talk about or not. So that is a current statutory requirement for condominiums. I think that the vast number of associations tend to meet more frequently than that, so it doesn't tend to pose a problem, but for some of the smaller ones, they may not.
Randy in Boynton wants to know, when a board is fining the owner for violations in a condo, does the board need to provide evidence both to the fined owner and to the grievance committee?
Well, what he's calling the grievance committee often is referred to as the fining committee. And the short answer is yes, there does need to be a case presented by the association to the fining committee, grievance committee, of whatever issue has occurred that resulted in the board wanting to impose a fine. It's kind of like an internal court where the fining committee is the judge and jury, the association is the prosecution, and the owner is the defendant. And the association presents its case as to why the fine should be imposed, and the owner presents his case as to why it shouldn't, and the fining committee says yes or no. That's its basic function. It's not a function of the committee to try and negotiate or say, well, board, we understand you've adopted a fine for $1,000, but we're only going to charge them $500. The committee doesn't have that kind of authority. Their basic authority is yes or no to what the board has adopted.
We just got a text from a listener. I always enjoy your show. What is the question? I'm a property manager. What kind of questions are you mostly getting?
In our show or in general?
I think they mean at the office in general.
It's everything that you can possibly think of. There is no, we don't really keep track of what we mostly get or don't get. This time of year, there's a lot of election-related questions because the election season is coming into place. Obviously, for the condominiums, the situation with the structural integrity report and reserve requirements are a big issue. The law does allow for a one-time opportunity to waive the structural integrity reserves if it's done before December 31st of 2024. After that, those types of reserves aren't going to be waivable anymore. So a lot of associations are interested in going about that or figuring out whether they want to do that. But there's such a wide range of things.
She just did a follow-up. She said, I meant with all the new laws that have come out.
Well, again, there's so many laws that they all tend to be, they come up at some point or another. So what I'm hearing is a lot of the reserve waiver at the moment.
Okay. Pete in Fort Lauderdale, what are your thoughts on waiving CSRS reserves for the year till next year, starting in 2026? Is it possible? Are there any negative to doing it? And your thoughts?
Well, it's from my perspective, it's whether or not it's what the law allows, not whether or not we should or shouldn't. Whether or not we should or shouldn't is a business decision that the board members make, and it's not for their lawyer to tell them whether they should or they shouldn't, and we don't do that. We tell our clients what could happen if you do this, what could happen if you do that. Here's the risk of this, here's the risk of that, and then they get to decide how much risk they want to take on and which course of action that they'll pursue. The obvious downside of waiving the reserves is that you're not going to have the money in place. So next year it's going to be a larger requirement of what you're going to have to set aside based upon whatever report you get from the expert. But many communities have been waiving reserves for years and years and years, so they're used to it. The legislature decided that they weren't going to allow for that anymore. And for those that are waivable, they've increased the percentage of owner requirement needed in order to accomplish that. It used to be a majority of those who attended a meeting in which a quorum was present, and they raised it to a full majority. So that's a higher number of owners have to approve what can be waived. But the business decision of whether or not to do so tends to be one more management is supposed to be advising upon as opposed to the lawyer.
Here's a comment from a listener. In violation fine situation, when there is no evidence presented and it's a board's word against the owner, can the committee decide or this is an improper situation?
The committee's power with fining is yes or no from what the board is requesting. And based upon whatever the board presents to meet whatever requirements are necessary to qualify for a fine, the violation exists and has been ongoing for however long it's been ongoing to reach the level that the fine has reached. And then the committee's choice is either yes or no.
We're going to get a couple more questions in here before our first commercial. And we're also we want to go over, God, you've got a busy month. Let me just get to Marie in Boca Raton. Why not just get rid of all this HOA and condo stuff and let everyone deal with their own property?
Well, unfortunately, the way Florida is structured, we're pretty entrenched with having communities with covenants in place. And once they're in place, they're very difficult to get rid of. One of the main reasons that these exist, well, first with condominiums, they don't exist without the statute. Condominium ownership is basically you own the airspace that's in between the four perimeter walls of your unit, the outside walls, the floor, and the ceiling. And everything inside is what you own. And in real property law, you need to own some actual ground in order to own real property. So condominiums were created by statute as a means to allow for ownership of the airspace to be treated like real property, because there is real property involved underneath the building. There's real property, and so that's how condominiums came about in the 60s. Obviously, it's evolved significantly since then, with many different laws in place and changes constantly happening year to year. Particularly in Florida is one of the leading states in the country that have so much legislation on condominiums, and has been one of the first in the country overall to have them. Cooperatives were kind of popular before that as another means. In a cooperative, it's different in that there's a corporation that owns the building, and the people own stock in the corporation, and they get a lease for their unit. That's a different method of ownership. But in the homeowner association arena, a lot of that is the cities, counties, municipalities don't provide the same level of services and tax rates as in other states. And a lot of that was shifted to the community associations through the years, and that without them, there's a lot of upkeep and maintenance situations that aren't going to occur on the common properties, on the roads, and certainly when there's a gated community, there has to be some form of internal mechanism, because it's private property completely. There is no public property in a gated community. So it's going to be difficult to check the whole thing and not have the laws. Where there's a technical issue in the homeowner side is some of the laws that have come into place go beyond what they typically are allowed to do under general constitutional limitations by affecting existing contracts that are in place. The covenants are contracts. And unless there's certain language in the documents that incorporates future changes to the statutes, some of those statutes which people think apply to their communities do not, because they're only bound by what legislation was in place when they were created. And that's a very complicated and technical aspect in the law that confuses a great many people, including judges. And so it's important to review each of these situations that come up as they come up, with the first look at whether or not the community is bound by such changes when they occur. One example of that has come up frequently this year is limitations that were put in place on vehicles that can be stored within communities and HOAs. Many HOAs have vehicle restrictions written into their covenants, and the legislature decided they're not going to allow you to enforce that. Well, unless your documents incorporate the changes to the statute, that's an unconstitutional provision in the legislation, and not enforceable in that particular community. The homeowner generally doesn't know that, doesn't think in those terms, and that's creating additional conflicts within the communities that are addressing situations such as that. So that's an area of the law that has become somewhat prevalent in the last couple of years, particularly as the legislature has been trying to add things into the homeowner association statute.
You know, I've asked this question many a times before, but we just got a text. Somebody is going to be running for the board, and he wants to know what kind of qualifications you need or you should have.
It depends on the documents for the community. It ranges from 0 to the requirement of owning a unit within the community, or a lot if the HOA or whatever property they have under the covenants. So the governing documents will typically set up qualifications. As far as real life qualifications, other than being over the age of 18, there isn't anything specific. In fact, sometimes qualifications in somebody's other life before getting involved in the board sometimes hamper their ability to perform their function on the board. One of the best qualifications is an open mind and a willingness to consult with hired experts that the association needs: management company, accounting firm, law firm, engineering, the various professionals that provide services, and as they make their decisions. And it's important to be willing to make decisions. That's another issue that a lot of times we see, where a board member is unable to make a decision because it might affect their friend, or it might make them unpopular in the community, or whatever reason it might be. But a director has a responsibility to the community. It's called a fiduciary duty. It's a higher level of responsibility to make the decisions appropriately and actually make the decisions.
He just did a follow-up. He wants to know, do you have to have had running a business as a qualification?
Generally, no. It may help from understanding the way business works. And since you are running a business when you're running an association, but running a dry cleaning business is not the same thing as running a homeowner association. The issues involved are quite different. So yes, it helps to have some business experience, but again, you need to be able to use the services of the professionals who are available to the association. And there are many good professionals, but make sure the one you have is sufficiently competent.
Robert, we're going to go to break, but before we go to break, let's go over your schedule for the month of November for your classes.
Okay, well, the first upcoming we have is on Tuesday, November 12th, Zoom from 12 p.m. to 1 p.m., Community Roundtable, Technology and Community Governance. It's being sponsored by Get Quorum, and Kirsten Hens of our Tampa office will be participating in that. On Wednesday, November 13th, at 8 a.m. to 4:30 p.m., there's going to be a expo at the Orlando Convention Center. Alan Schwartzide will be there with his staff. We have 2 courses that we're presenting at the expo. At 9:30 to 10:30, covenant enforceability of HOAs and condominiums. And at 2:30 to 4:30, there's going to be a 2024 legal update, for which there's going to be some continuing education credits, as Alan Schwartzide will be presenting both of those courses. Also on Wednesday, November 13th, from 12 p.m. to 4 p.m. on a Zoom, we're presenting condominium board member certification webinar with Danielle Brennan from our Palm Beach Gardens office and Andrew Black from Pompano, and that's hosted by Real Manage. On Thursday, November 14th, from 12 p.m. to 2 p.m., on a Zoom course, we have the 2025 legal update, a new class. It also has continuing education credits. And we've got Lisa McGill from our Pompano Beach office will be working on that one. It's hosted by Campbell Property Management. Then on Friday, November 15th, at 11:30 to 1 p.m. at the Venice, Florida Golf and Country Club, there's a luncheon. And we'll be presenting elections for condominiums, cooperatives, and homeowners association. Kirsten Hens from the Tampa office will be providing the instruction. It's hosted by Charlotte Venice Manager and Board Member Group. That one's going to take some travel. On November the 19th, Tuesday, from 12 p.m. to 3 p.m., an HOA Board Member Certification webinar. The instructor, Kirsten Hens from Tampa. It's hosted by KW Property Management. And the last item before Thanksgiving, Thursday, November 21, from 5 p.m. to 8 p.m., the board member certification webinar. That's a 4-hour course or a 3-hour course. Emily Gannon from our Pompano office will be the instructor, and that's hosted by the city of Tamarack.
These are all free, right?
All free. Go to the website, kbrlegal.com, choose the event in the calendar section and register so that you can get the Zoom credentials for the Zoom items, and for the ones that are in person. At the Orlando Expo, it's good to pre-register, but if you just go there and walk in, you'll be certainly welcome. But we want to have enough materials so that everybody gets them. And that's how we'll go.
Okay, we're going to go to break. Give everybody the phone number they can reach at the office.
Reach us at 800-974-0680. You can write to info@kbrlegal.com, or just go to the website, kbrlegal.com, and there's a contact box on the main page, and fill that out, and we'll get back to you.
We're going to go to break. We'll be right back with attorney Robert Kay.
K. Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rembaum attorneys are board-certified specialists in condominium and plan development law, and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rembaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
Yeah, welcome back. This is the Ask the Expert show. This is the first Thursday of the month, so that means K. Bender Rembaum, our community association law firm. They have been with us for over 10 years now, and this is a service. There's not too many law firms that offer this, and this way that they can get out and answer your questions. Robert's with us every month, and he's also got associates of his in Tampa and Orlando that we run shows with. Let's get back. Let's go to Craig and Davie. The bylaws state 10 days notice for a board meeting. Statute says 48 hours. Does the stronger of the law applicable?
Well, it depends on what you'd consider the stronger. We tend to view that as whatever is better for the owners is what we would recommend the association to apply. And I assume we're talking about posted notice versus actual notice to board members or owners. The question isn't entirely clear as to what they're referring to or whether it's condo or HOA. So the general thought on this is that if the bylaws have a longer notice requirement than the statute, we tend to go with what the documents say, the bylaws. You can be more restrictive in your documents than the statute is. You can't be less. And more notice to owners is considered more restrictive to the association than less notice. So that's the thought process behind choosing which one to apply in that setting. Now, I was reminded during the break of one other point about the upcoming certification courses that the listeners should be aware of, as we've seen occur. If you're in a condo board, it's important to go to the condo certification, not just whichever one comes up. And you're an HOA, go to the HOA one. If you go to the condominium one, it's not going to certify you for your HOA board seat. So it's important to focus on what you've got, what you're representing, and make sure you attend that particular class. Okay. Now, there are people out there giving combined classes, and that will cover both ways.
Stephen in Coral Springs, is the grievance committee meeting an open meeting as in open to all the owners of the condo association?
Well, in a condominium, committee meetings are generally treated the same as board meetings and would require posted notice and being open to unit owners to attend. Now, the participation side of unit owners at a finding committee or grievance meeting is probably not as appropriate as it may be in a board meeting. That could tend to get a little bit out of control when the finding committee is trying to determine whether or not to find. The input of the owners might not be relevant to the actual issue, and it might be more emotionally based than fact. Now, if the owner who's the focus of the issue before the committee is bringing witnesses to assist in presenting, then that's certainly an acceptable participation at the grievance committee setting.
Greg in Palm Beach Gardens, I look forward to every month to your show. I learned so much. Is it easier to amend the Florida Constitution than to get the legislator to act?
Well, it's different. I don't know if I'd call it easier. As we've seen this past week, we have a supermajority requirement in Florida that's, I think, the highest in the country at a 60% requirement in order to change the Constitution. And there are pros and cons for that. And certainly the pro of that is you don't want it to be so easy to make a constitutional change because it's the Constitution. But you also don't want it to be so hard that you're never going to be able to do it. So it's a fine balancing act to do that. When you get 57% and you need 60, it's probably frustrating to those who are on the side of passing it. And that's what was voted on by the people of the state of Florida at some point. So that's what they live with. Legislators, getting them to move is a whole nother process, and it usually involves a lot of lobbying and the personal interests of the legislators involved in creating and adopting whichever bill they're dealing with. It's a very involved and complicated process that I personally avoided in my career. Michael Bender here is much more involved in the legislative process than I have ever been. And that's probably because he enjoys that stuff. My focus has generally been what they've done and how it affects some of our clients, and then what we do going forward. And that's generally the focus that I've followed.
We just got a text from Randy in Miami, wants to know, do you see any of these new laws changing next year because of some of the problems that are occurring?
Well, there's always attempts being made to fix things that have resulted from the exuberance of the legislature. One of the issues that is the focus of attempts is the situation with the structural integrity reserves that are being required and the time frame in which that's being imposed. And we've seen stories in the newspaper and on TV about condominiums that are facing very large assessments and having to putting owners in a position where they can't afford to live there, driving up the costs of living in these places. And when legislatures were asked about that at recent discussions, one stated that it was an unintended consequence, which seems a little strange that the legislator wouldn't recognize that level of effect of something as significant as what was adopted. Whether or not they're going to be able to get something through to change that, give extensions or temper it to a way that doesn't hurt the condominium industry as much as is likely going to happen in the next year or two, that's an open question. There's always lobbying going on through the Community Association Institute and other groups of interested parties in the state, and there are lobbyists involved that are constantly working to address these issues and come up with new legislation that would be beneficial to associations. And given the process, it's just an open question as to what's actually going to occur.
Got another text in from Jackson in Fort Lauderdale. He wants to know, if I can read this right, the developers are getting ready to turn over everything to our new board. Do we have to use their lawyers?
That's a common situation that occurs. The developer should have a developer lawyer and should have an association lawyer, and it shouldn't be the same person. The developer's lawyer is representing the developer's interests, which are different than the association's. Through the years, we've taken on associations that were still under developer control, but we don't represent the developer, we represent the association. And right. Sometimes the developer only has the one lawyer, so it's going to be up to the board when they take over from the developer, whether they feel comfortable with the attorney, are they sufficiently independent from the developer and be in a position to raise claims against the developer that the owners may have, or were they tied to the developer that they'd be in a conflict situation. We've had situations where the new board doesn't trust the fact that we might be sufficiently independent, but do appreciate our expertise in the area of operating the association, so they'll keep us on for that, and we can put them in touch with another law firm that can handle the developer claims, and then they get the best of both.
I say hire K. Bender Rimbaum to represent you. Kathy and Sunrise.
As a rule, we don't represent developers. There are a couple that the Palm Beach Gardens office does represent, and we're full disclosure, so that it's not an issue. But generally speaking, our client base is associations.
Kathy in Sunrise, I heard board members for HOA don't have near the powers they used to have. Is that true?
Well, I'm not sure what powers she thinks they used to have that they don't anymore, but they still have significant powers in operating the communities as are laid out in their governing documents. The statutory changes have certainly made attempts to whittle away at certain powers that board members may have enjoyed. But one thing that's different from condominiums in the homeowner association setting is there is no state agency that oversees homeowners associations as there is for condominiums. So if there are issues with addressing concerns with what the board may be doing, overstepping or whatever, the remedies are only going through hiring a private attorney and taking it to court. In the condominium setting, they've got the division of condominiums in place to address many of the issues, and the legislature had reduced the division's authority, but in the most recent legislation last couple of years, they've tried to expand it a little bit. And the division certainly has been happy to take on additional jurisdictional entitlement and flex their muscles in that respect, but that's for condominiums, not for HOAs.
You know, I'm really proud of our listeners and viewers. They never used to tell us if they were an HOA or a condo.
They were getting them trained.
And now they're starting to do it more.
Well, it's certainly helpful.
Yeah. So here's Julie in Pompano Beach, HOA. On the website, what documents go on the front page open to the public, and what documents go on the members only sign-in portal protected area?
Well, the only documents that should be open to the public are what's in the public records. The governing documents are in the public records of the county, so they're available in other places. They're not confidential. It's okay for those to be there. Anything informational about the community that isn't necessarily a record is certainly okay. But anything that's technically an official record as defined by the statute, other than the governing documents, should be in the members only section.
Cindy in Palm Beach wants to know, do we have any recourse if board members are kicked other board members off?
Well, generally speaking, board members don't have the power to remove other board members. It takes recall, and that's a vote of the owners. There are certain situations where there are classes of owners that appoint board members. For example, you have a master association over 3 condominiums, and each of the condominiums appoint their own representative to the master board. The other board members couldn't remove any one of them, but the condominium that they're representing could, and that might be done by the board there, but not through a vote of their owners, depending on how that structure is. That's a unique one, different from the general. In the general situation, if the board removes a board member improperly in an HOA, unfortunately, the recourse is through court action, and the removed director likely needs to participate in order to have what the courts call standing, the legal position to allow it to make the claims to the court. If somebody's not sufficiently interested from the court's perspective in whatever issue is being brought, they're said to not have standing to bring the case. Now, we see that on a number of issues in the newspaper from time to time. Something gets dismissed because they didn't have standing to bring the case. That's because they didn't have a sufficient legal interest in the dispute to bring it to the court. So the removed director would best be a part of that lawsuit in order to avoid that potential defense.
Robert in Deerfield wants to know, what is the statute of limitations on challenging changes to HOA documents? Is it 5 years challenging the amendment?
There are cases that have been decided, appellate cases in Florida, that have put 5 years as the time frame within which to make the challenge. But the question that isn't as clear as we would like is 5 years from when. Ideally, 5 years from when the change was made and recorded in the public record. That would be my perspective. But I've seen courts that have gone from the time the owner acquired their interest. And in one case, the owner purchased after the amendment was adopted and still was allowed to make a challenge on the amendment, even though they bought with the amendment in place. So the rule of thumb is 5 years from when the amendment is recorded in the public record.
Okay. Stephen in Boca Raton, if a board member has not paid their assessment, can they be kicked off the board?
Well, both HOA and condominium statutes, and cooperatives for that matter, do have provisions that if a board member is delinquent in the payment of assessments in certain amounts over certain periods of time, they're automatically off the board. So there's no kicking, they're just off as a matter of law. So depending on what this is, you'd want to just confirm what the time frame and the dollar limit might be in the statute to determine when that would kick in on the individual board member. Now, one thing to bear in mind is there was a situation in a condominium where they provided it, they were delinquent for 90 days, that they would automatically be off the board. And what the director would do was they would pay part of what was outstanding, thinking that they were never 90 days completely owing to the association, but the time of their delinquency was more than 90 days. And the division gave an opinion on that case that once the delinquency starts, that's the starting point of the 90 days. And you have to catch up to a zero balance in order to not be 90 days or more. So you can't play the game of paying partially to stay less than 90 days in total dollars, because it's a time frame, not a dollar frame on that particular point.
Robert, you know, we've been doing this show for a long time, and I don't think I've ever done this. We have some incredible listeners and viewers who have such great questions, don't we?
They actually do, yes. I always enjoy hearing your questions.
Yes. You know, you're back with us next month, first Thursday. So we want to wish you a happy Thanksgiving, you and your family.
Thank you. Same to you and yours and everybody listening.
And we want to thank you, Robert, because you've made this show what it is, and you give your time every month, and we know how busy you are. Tell people how they can reach the office and your website.
You can call 800-974-0680. You can write to us at info@kbrlegal.com. You can go to the website, kbrlegal.com, and fill out a contact requests form on the main page. You can send us a letter if you want. The addresses of the various offices are on the website as well. I don't think we've ever mentioned that before.
Oh, yeah.
If you want to use snail mail, you also can do that.
Again, Robert, have a wonderful Thanksgiving, you and your family.
Same to you.
You're wonderful. You'll be back again with us next month, first Thursday of the month. Thank you, Robert.
Looking forward. Bye-bye.
That's attorney Robert K. Bender Rimbaum. Hey, that's going to do it for us today. We'll be back again with you next Thursday. with more Ask the Experts. Thank you, Juan.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.